everybody. In today's video we will be talking about the marital rape cases in India. So before starting, do you think it is actually recognized in India and penalized in India? Let us find out. So marital rape are basically means any unwanted sexual activity by a spouse or ex-spouse that is committed without the other person's consent. Such illegal sexual activities are done using force, threat, intimidation, uh, or when a person is unable to give consent. So the sexual acts include intercourse, anal, oral sex, forced sexual behavior with the other individual, and uh, such other sexual activities that are considered by the victim as disregarding, humiliating, painful, and unwanted. So this marital rape is also known as spousal rape. So in the same regard, we have few judgments. The first judgment is Harikesh Sahu versus State of Karnataka. So the Karnataka High Court in April 2022 stated that a man can be punished for raping his wife. So the order stated that, I quote, a rape is a rape, be it performed by a man, the husband, on the woman, the wife, I unquote. The order came while the Karnataka High Court was hearing a petition filed by a man for dropping off the rape charges levied upon him by his wife. So the rape comes under the ambit of cruelty and hence can be a ground for seeking divorce. This was held by the Karnataka High Court, and the same was upheld by Supreme Court that allowed the trial of the husband. Further, in the case RIT Foundation versus Union of India, the division bench of Delhi High Court delivered the split verdict regarding the criminalization of marital rape. So Justice Sakhder and Justice C. Hari Shankar were the two judges who were the bench that decided for the first time the constitutional validity of exception in rape law concerning a man and his adult wife. So Justice Hari Shankar held that a man is exercising his rights vested in him by marriage. So if he is asking for, his wife for sex, or even if he is forcing himself on her, it cannot be compared to the act ravishing by a stranger. While Justice Rajiv Shakder allowed the petition and called for the exception of section 375 of IPC to be struck down. While Justice C. Hari Shankar ruled that the provision should remain in the statute book. Further, in the case of Khushbu Safi versus Union of India, after receiving this conflicting verdict, the Supreme Court sought the central government's response in the appeal against the split verdict of the Delhi High Court in the marital rape case and on the validity of exception 2 of section 375 of IPC. So concluding today's topic, the concept of marital rape is nothing which is unknown to us, and it is the most common repugnant practice which is under the veil of marriage. So the provision of section 375 exception 2 of IPC 1860 provides for an exception to the person committing marital rape, committing so-called rape with his own spouse, condition being that his wife should be above 15 years, is not a rape. So do you think it is right to put an age barrier, and do you think there should be a age barrier to this? Do let me know in the comment section. Thank you.